Welcome to SQE1 preparation, criminal practice, plea before venue allocation, and either way offences by street lawyer, helping you to pass first time. The FLK2 criminal practice and what the SQE expects you to know, and I'm really focusing on either way offences. So you can see in the red, I'm focusing on plea before venue. Procedure on defendants entering a plea, advising the client on trial venue, allocation of business between Magistrates Court and Crown Court, procedure sections 19, 20 and 22A of the Magistrates Court Act 1980, and sending without allocation section 50A and section 51 of the Crime and Disorder Act 1998. All of this relates to either way offences. So in the learning outcomes, by the end of this class, you will hopefully be able to understand the procedure for plea before venue and allocation, advise clients on trial venue choices, explain CPS disclosure obligations, but more importantly, focus on describe what happens at the first hearing for either way offences. And I've done a separate video about what happens at the first hearing at the Magistrates Court for summary and indictable only offences, so please watch that video as well. By way of SBAQ tips, these may centre on knowing the different processes involved for summary, either way, and indictable offences at the first Magistrates Court hearing. This means it's essential you know the offence categorisation, whether an offence is summary only, either way, indictable. And I think the focus on the SBAQ questions that I've seen tend to focus on some of those exceptions to the general rule, which SQE tends to focus on: criminal damage less than £5,000, arson where damage is less than £5,000, criminal damage of a memorial less than £5,000, low value theft less than £200, and the 3 strikes rule in burglary offences. So know what happens at the first Magistrates Court hearing when you have these type of offences. The second tip is understand in summary only and indictable offences, the defendant does not have a right to elect trial at the at the Crown Court. In other words, a trial by indictment. Thirdly, understanding where there is no allocation hearing in an either way offence, because there are certain occasions when there are no allocation hearings. Understand what happens in the case of 2 or more defendants who are jointly charged and where the case will be tried. If one wants to be tried in the Crown Court and one wants to be tried in the Magistrates Court, what happens in that scenario? And what is also important to know is what the best advice is where a defendant has right to choose a trial at the Magistrates Court or the Crown Court based on the case facts. It's important to know the factors for and against a trial at the Magistrates Court and for and against a trial at the Crown Court, or what is also known as trial by indictment. So there's a lot to think about when it comes to this topic, and that might explain why there are 11 test your knowledge questions. So let's look at them in turn. So turning to test your knowledge 1, Tony is to appear in the Magistrates Court charged with an offence of criminal damage by arson. It is alleged that he set fire to his neighbour's garden shed. £2,000 worth of damage was caused. Tony will indicate a guilty plea to this offence. Which of the following best describes what will happen when Tony appears in court? A, B, C, D, E. Tony will plead guilty and the magistrates will then sentence him since the value of the property damage is under £5,000. B, Tony will be expected to enter his plea and the magistrates will then have to decide on allocation, as this is an either way offence. C, Tony will plead guilty and the court will then adjourn the case for the preparation of a pre-sentence report. D, Tony will not be asked to indicate his plea, as arson is an offence that can only be tried on indictment, so his case will be immediately sent to the Crown Court. Or is it E, Tony will be expected to indicate his plea and he will either be sentenced by the Magistrates Court or committed to the Crown Court for sentence. Turning to the next test your knowledge 2 question. Tony makes his first appearance before the Magistrates Court charged with section 20 assault. His solicitor is in receipt of the initial details of the prosecution case, also known as IDPC. It is alleged that Tony approached the victim in the street and started an argument. When the victim attempted to walk away, it is alleged that Tony kicked and then headbutted the victim once to the head, causing a cut to the victim's eye that required several stitches. Tony intends to indicate a plea of not guilty. Which of the following statements is correct in relation to the allocation procedure? Is it A, B, C, D, or E? Tony must be tried in the Crown Court because of the nature of the offence. Or is it B, Tony must be tried in the Magistrates' Court because of the classification of the offence? C, Tony can elect to be tried in the Magistrates' Court or the Crown Court? Or is it D, Tony must be tried in the Magistrates' Court if the magistrates accept jurisdiction? Or is it E, Tony may be tried in the Magistrates' Court if the magistrates accept jurisdiction and he so consents? Turning now to testing knowledge 3, Tony has been charged with an offence of section 47 ABH and he is intending to plead not guilty. It is likely that the Magistrates' Court will accept jurisdiction of this case due to the nature of the offence itself. The man wants to ensure that he has the best possible chance of being found not guilty, because if he is convicted, it would adversely affect his career and future employment prospects. Assuming Tony is given a choice at the allocation hearing, what is the best advice to give him regarding which trial venue he should choose? Is it A, B, C, D, or E? A, Tony should choose the Magistrates' Court because they have limited sentencing powers, which could result in the client getting a lesser sentence if he is convicted. Is it B, Tony should choose the Crown Court because statistically they have a higher acquittal rates? Is it C, Tony should choose the Magistrates' Court because it is less formal and will be a better environment to put Tony at ease? Is it D, Tony should choose the Crown Court because there will be more time to prepare for his trial? Or is it E, Tony should choose the Magistrates' Court because it will be cheaper for him than going to the Crown Court? Turning to testing knowledge 4, Tony makes his first appearance before the Magistrates' Court charged with theft of a laptop. Tony pleads not guilty at the plea before venue hearing at the magistrates, and the magistrates decide that the case is suitable for summary trial. Which of the following statements would be a legitimate reason for Tony to consent to trial in the Magistrates' Court? Is it A, B, C, D, or E? A, Tony should consent to summary trial because if granted legal aid, he will not be required to contribute to the costs incurred by the prosecution. Is it B, Tony should consent to summary trial because the procedure for deciding on the admissibility of disputed prosecution evidence is better for the defendant in the Magistrates' Court? Is it C, Tony should consent to summary trial because if convicted, he will have to be sentenced by the magistrates? The sentence powers available to the Crown Court judge are much greater. Is it D, Tony should consent to summary trial because if granted legal aid in the Magistrates' Court, a defendant is not required to contribute towards his defence costs? The defendant may be required to do so in the Crown Court. Or is the answer E, Tony should consent to summary trial because in the Magistrates' Court there is no obligation on the defendant to submit a defence statement until the prosecution has made its initial disclosure of unused material. Turning now to test your knowledge 5, Tony makes his first appearance before the Magistrates' Court charged with criminal damage. It is alleged that he struck his neighbour's caravan with a baseball bat, causing damage to the value of £6,000. Tony refuses to enter a plea. Which of the following statements best describes what will happen next? A, the magistrates will send Tony's case to the Crown Court for trial for the offence of criminal damage. B, the magistrates will sentence Tony for the offence of criminal damage. C, the magistrates will commit Tony's case to the Crown Court for sentence for the offence of criminal damage. D, the magistrates will adjourn Tony's case for trial to the Magistrates' Court. Or E, the magistrates will determine whether the offence appears more suitable for trial in the Magistrates' Court or the Crown Court. Turning to test your knowledge 6, Tony is charged with burglary of a charity shop, an either way offence. It is alleged that he entered the shop via an open window at the rear and stole 3 mobile telephones from handbags in the staff room. The total value of the telephones was £500. Tony has 2 previous convictions for burglary. When interviewed by the police about the offence, Tony denies that he is responsible. At the first hearing in the magistrate's court, Tony tells his solicitor that he will plead not guilty and asks what will happen after he enters his plea. Is the answer A? What is the best advice the solicitor can give to Tony? Is the answer A, B, C, D, or E? A is the court will adjourn for the preparation of pre-sentence report. B, the court will send the case to the Crown Court for trial. C, the court will determine whether the trial will take place in the Magistrates' Court or the Crown Court. D, the court will fix a date for Tony's trial in the Magistrates' Court. Or is it E, the court will issue case management directions with which the prosecution and defence must comply before the trial? Turning now to Test Your Knowledge 7. Tony appears in the Magistrates' Court charged with an offence of assault occasioning actual bodily harm, section 47, and an offence of theft. At the plea before venue hearing, he indicates a not guilty plea to the assault matter and a guilty plea in relation to the theft matter. The magistrates accept jurisdiction to deal with the assault, but Tony elects trial on indictment. Which court will sentence Tony for the offence of theft? A, the Magistrates' Court will sentence Tony for the offence of theft as they have already accepted jurisdiction to deal with the assault matter. B, the Magistrates' Court will have a choice to either sentence Tony for the offence of theft or to commit him to the Crown Court to be sentenced there. Or C, Tony will be able to choose which court he is sentenced by. Is it D, the Crown Court will sentence Tony after his trial for the assault matter has been concluded? Or is it E, the Crown Court will sentence Tony before his trial for the assault matter takes place? Turning now to Test Your Knowledge 8. Tony has been charged with an offence of Section 18 GBH and Section 47 ABH assault in relation to the same complainant. Both are alleged to have occurred within a few days of each other as a result of an ongoing feud. Tony intends to plead not guilty to both charges and wants to know which court or courts will deal with these cases. Which of the following best describes the advice Tony should be given? Is it A, B, C, D, or E? A, both cases are likely to be tried in the Crown Court as Section 18 GBH is triable only on indictment. B, the Section 18 GBH charge will be dealt with in the Crown Court and the Section 47 ABH charge may be dealt with in the Crown Court if the magistrates decide their powers of punishment are inadequate to deal with it. C, the Section 18 GBH charge will be dealt with in the Crown Court and the Section 47 ABH charge will only be dealt with in the Crown Court if the man elects trial on indictment. Is the answer D? Both cases will be tried in the Crown Court as both charges relate to indictable offences. Or is the answer E? Both cases will be tried in the Crown Court as Section 47 ABH charge is related to the Section 18 GBH. Turning now to Test Your Knowledge 9. Tony has been jointly charged with an offence of Section 47 ABH with Steve. At his first court appearance in the Magistrates' Court, his solicitor advises him on plea and trial venue before his case is called on. Tony intends to indicate a not guilty plea and decides to consent to summary trial if he is given the choice. Which of the following best describes whether Tony's trial will take place in the Magistrates' Court? Is it A, B, C, D, or E? A is if both defendants consent to summary trial, the trial must take place in the Magistrates' Court. Or B, if the defendant consents to summary trial, the trial is likely to take place in the Magistrates' Court regardless of the other defendant, Steve's decision. Or is it C, if the magistrates decide the offence to be more suitable for summary trial and both defendants, Tony and Steve, consent to summary trial, the trial will take place in the Magistrates' Court? Is the answer D, if Tony consents to summary trial, the trial is likely to take place in the Magistrates' Court even if the other defendant, Steve, elects trial on indictment? Or is the answer E, if the magistrates decide the offence to be more suitable for trial on indictment and the other defendant, Steve, also consents to summary trial, the trial will take place in the Magistrates' Court? Then we have Test Your Knowledge 10. This is a sample question from the SRA's website, so please pay careful attention to this. A man is charged with the burglary of an unoccupied dwelling house from which electrical goods are stolen. He is released on bail from the police station to attend the first hearing at the Magistrates' Court. The man has no previous convictions. The man's solicitor receives the initial details of the prosecution case, also known as IDPC, before the first hearing and takes the man's instructions. The man denies this allegation of burglary, and his solicitor advises the man to indicate a not guilty plea at the first hearing. The man tells the solicitor that he would like to be tried at the Crown Court by a jury. He asks his solicitor how the decision will be made as to where his trial for the offence of burglary will take place. So the question here is what advice should the solicitor give in relation to how the decision will be made as to where the man's trial will take place? A, B, C, D or E? A, the magistrates will decide whether to accept jurisdiction for trial, and if the magistrates accept jurisdiction, the man can choose to be tried at the Crown Court by a jury. Or is it B, the magistrates must send the case to the Crown Court for trial and the man will be tried by a jury? Or is it C, the magistrates have exclusive jurisdiction over the man's case and he cannot be tried at the Crown Court by a jury? Or is the answer D, the magistrates will decide whether to accept jurisdiction for a trial, and only if the magistrates decline jurisdiction can the man be tried at the Crown Court by a jury? Or is the answer E, the magistrates will invite the man to choose whether to be tried at the Crown Court by a jury? And then the final test of knowledge, 11, which is a set of true and false statements. So number 1 is, either way offences are always tried in the magistrate's court. Is that true or false? 2, IDPC, the initial details of the prosecution case must be provided before the first hearing. Is that true or false? 3, defendant has no say in trial venue if the magistrates accept jurisdiction. Is that true or false? 4, a guilty plea at plea before venue always results in sentencing in the magistrate's court. Is that true or false? Voir dire hearings are exclusive to the Crown Court. Is that true or false? The magistrates must provide reasons when they decline jurisdiction for an either way offence. Is that true or false? 7, defendants are always better off electing Crown Court trial. Is that true or false? CPS disclosure obligations include providing defendants' criminal record. Is that true or false? 9, if one co-defendant elects trial in the Crown Court, all co-defendants must follow. Is that true or false? And 10, magistrates can commit a defendant to the Crown Court for sentence if their powers are insufficient. Is that true or false? What follows now is, like all the other classes we've had, all the videos we've been doing, is we then go through the content of the topic. Remember, the focus is what happens for either way offences at the first magistrate's hearing. So we're not looking at summary only offences, we're not looking at indictable offences, we're looking at either way offences. So what is an outline of the procedure for an either way offence at the first hearing? Well, the initial steps are defendants charged and appears at the magistrate's court, the IDPC, the initial details of prosecution case provided to the defence. There's a private meeting that takes place between the defendant and defence solicitor. There's a plea before venue that takes place where the defendant indicates plea guilty or not guilty or no plea. There's an allocation hearing that takes place. If it's not guilty or no plea refusal to indicate plea, court decides that venue either is at the magistrate's court or the Crown Court. If it's a guilty is indicated, court treats this as a guilty plea and decides on sentencing venue either at the magistrate's court or the Crown Court. And there are certain occasions when either way offences are where there's a sending without an allocation, meaning it's been sent to the Crown Court without the need for an allocation hearing. And this applies to specific cases such as complex fraud. And then we ask the question, what is a plea before venue? Definition is the first procedural step for an either way offence. The court asks the defendant how they would plead if the case proceeds to trial. It's the indication of plea. So the steps are legal advisor explains the options. Defendant indicates guilty plea or not guilty plea, or refuses to indicate plea or remains silent. If not guilty plea or refusal to enter plea, the case proceeds to an allocation hearing. If it's a guilty plea indicated, magistrates treat this as a guilty plea being entered and decide on sentencing at the magistrate's court or committing to the Crown Court for sentencing. And check out section 19. So then what is an allocation hearing? The purpose of this is to determine where the case will be tried summary in the magistrate's court or proceed to the Crown Court on a trial on indictment. The court considers a couple of factors: the sentencing power of the magistrates and the nature and seriousness of the offence, the allocation guidelines given to magistrates, and the defence choice. If the magistrates accept jurisdiction, the defendant can elect trial venue, either the magistrates or the Crown Court. Magistrate, summary trial. Crown Court trial by indictment, and check out sections 19 to 20. Question: what determines what happens at the first hearing? We've said this in the past in another class. Factors influencing the first hearing: funding, how the case will be funded, legal aid or private fees, seriousness of the offence, know your classification of the offence is really important, summary, indictable, either way, defendant indication of plea, guilty versus not guilty, or refusal or silent, disclosure by the CPS, how complete it is. If the CPS haven't properly provided proper disclosure, the case is likely to be adjourned. That impacts on what happens in the first hearing, so no indication of plea is entered. And then you have legal advice, a pre-hearing preparation by the solicitor, which is basically the conversation, the meeting, the discussions that take place between the client and the defendant in a private meeting before the hearing takes place. Question is, what are the CPS disclosure obligations before the first hearing? Well, IDPC, the initial details of the prosecution case. This must include a summary of the offence, that's the charge sheet, the defendant's criminal record, key evidence, and victim's statement if available. Timing should be, the disclosure should be given prior to the first hearing. That gives a chance for the defence lawyer to go through the papers with the client defendant. On a practical note, defence should confirm receipt before a plea is entered. So just take that issue about what conversations take place between the solicitor and the client before entering a plea or indicating that plea. So what matters should the solicitor discuss with their client before entering a plea? So key discussions are the strength of the case against them, the prosecution case, also the weakness of the case, client's instructions on the facts, consequence of guilty versus not guilty plea, trial venue options, either magistrates and the Crown Court, which we're going to look at shortly, advice on venue, see the next slide, sentencing credit for an early guilty plea. We have to advise, defence lawyers have to advise the client whether they're going to enter a guilty plea or not guilty, that they have credit for an early guilty plea. And there are professional conduct issues as well here. There's a duty always to act in the client's best interest. Sometimes a case may be more financially beneficial for the solicitor, and the solicitor's firm if the case goes to the Crown Court than stays in the Magistrates Court, but you act in the best interest of the client. Therefore, if the advice is to have the case in the Magistrates Court, even if it's not financially beneficial for the solicitor or profitable for the firm, then the advice should be accordingly to the client's best interest. So the next two slides talk about the advice on trial venue. So what are the factors favouring a summary trial, a magistrates court trial? Well, there's a couple of them here. One is limited sentencing powers. Remember, the maximum is 6 months imprisonment for a single either way offence. It's a quicker resolution. Trials are faster in magistrates court from the first hearing to the trial date. It's, it could be a matter of weeks, months, not years for Crown Court. There's lower costs when it comes to reduce prosecution costs in the magistrates compared to the Crown Court. Legal aid wise, there's no contributions to be made to the defence costs at the Magistrates Court, whereas if there's a trial at the Crown Court, there's potential contributions to be made to the defence costs. And it's considered to be a less stressful environment in the magistrates compared to the Crown Court. Crown Court is a bigger room, there's a lot more people there, there's 12 members of a jury, there might be there's the judge, there are people wearing gowns, whereas in the Magistrates Court it's considered to be less formal than the Crown Court. So then we look at now the advice on trial venue, the Crown Court. So what are the factors favouring a Crown Court trial? Higher acquittal rates, juries are perceived to be more sympathetic, voir dire hearings, which means that hearings that take place without the jury being present, maybe even before the trial even starts. There's a much better procedure for challenging evidence in the Crown Court compared to Magistrates Court. Time for preparation is much longer. The lead time allows for better case preparation between the first hearing at Magistrates and the eventual Crown Court trial, which could take place in a year or 18 months or 2 years or even longer. And for complex cases, Crown Courts are considered better suited for dealing with complex cases. So there's a number of factors in favour of the Crown Court. Now, what you've got to work out is, in a given single best answer question, when you're looking at the defendant and the defence situation circumstances, what is your best advice as to where the case should be tried, either at the Magistrates and the Crown Court? And you're looking at those factors. So pay careful attention to the last two slides in order to answer those type of questions. Question: what happens at the first hearing for a guilty plea for an either way offence when it's indicated? Well, the process is this: guilty plea indication treated as entering a guilty plea. Magistrates decide sentencing in the magistrates court or committing to the Crown Court if sentencing powers are inadequate. The possible outcomes are therefore: 1, sentence immediately by the magistrates court, or sentence adjourned for the pre-sentence report, but sentence to be at the magistrates court, or sentence is adjourned and the case is then sent to the Crown Court for sentence. And just note this legal change that took place in November 2024. The maximum custodial sentence is 12 months for one or more either way offences at the magistrates court. That change took place in November 24. Before November 24, the maximum custodial sentence was 6 months for an either way offence. So there's a big change there. So the question here is what happens at the first hearing for a not guilty plea indication for an either way offence? There's an allocation hearing that's conducted. Magistrates decide on the trial venue. Magistrates either can accept jurisdiction, then defendant's right to elect a summary trial or a Crown Court trial. If the magistrates decline jurisdiction, the case is then sent to the Crown Court and the defendant has no right to elect. Now, question: when are either way offences sent without allocation? Remember, there are certain either way offences where there is no allocation hearing. The case is just simply sent from the first magistrates court straight to the Crown Court. And these are where there's a complex fraud case or cases involving children as witnesses, or it's an either way offence related to an indictable offence. So there is no allocation hearing. It's considered too complex, got children involved, and it's related to an indictable offence. It's off to the Crown Court. So can you summarise the procedure for either way offences at the first hearing? Defendant charged appears in the magistrates court. Initial detail of the prosecution case. CPS provides key evidence. There's a meeting with the solicitor and the client. There's a plea before venue. Defendant indicates a plea, guilty. Magistrates decide if sentencing powers are sufficient. If yes, sentencing in the magistrates court. If no, case is committed to the Crown Court for sentencing. If a not guilty plea is indicated, there's an allocation hearing. Magistrates decide jurisdiction based on the seriousness and the sentencing adequacy. Magistrates accept jurisdiction. Defendant can elect trial venue, magistrates or Crown Court trial. If the magistrates decline jurisdiction, the case is sent to the Crown Court for trial. And then you have special circumstances, which is where there's an indication of plea, but because it's too complex, fraud, child witnesses, related indictable offence, the case is then sent directly to the Crown Court without the need for an allocation hearing. So a couple of quick examples here on this slide and the next slide. If there's a guilty plea for an either way offence, say for example a defendant is charged with theft, £1,500, indicates a plea of guilty at the plea before venue. Magistrates accept jurisdiction, saying, yep, we can sentence you, we've got enough powers. They'll sentence the person to fine imposed, looking at the Magistrates Court sentencing guidelines. That's what MCSG are, Magistrates Court sentencing guidelines. The outcome, therefore, is much faster resolution and sentencing within the jurisdiction of the Magistrates Court. So the defence tips there are basically, look, highlights the benefits of an early guilty plea, the credit for and reduction of a sentence, and the limited sentencing power. Look how quick it is comparing to having the case being sent off to the Crown Court. And then you have another practical example here, not guilty plea case. A defendant is charged with an assault, ABH, indicates not guilty plea. Allocation hearing takes place. Magistrates accept jurisdiction, say they've got enough sentencing powers if the defendant wants the case to be dealt with at the magistrates. But the defendant then has the right to elect and elects a Crown Court trial. Case is sent to the Crown Court for a trial. It'll be sent for a PTPH first of all, and then it'll be listed for trial after that. The defence tips there are to explain the strategic choice for Crown Court, e.g. jury trial preference and higher acquittal rates. Now we return to the test your knowledge questions. Remember, there's 1 to 11, so feel free to pause the slides and read the question and read the answer. So this is test your knowledge 1, test your knowledge 2, test your knowledge 3, test your knowledge 4, test your knowledge 5, test your knowledge 6, test your knowledge 7, test your knowledge 8, test your knowledge 9, test your knowledge 10, and that's that sample question, remember. And finally, test your knowledge 11, those true and false statements. Remember, watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge being examined by reading the SRA website for yourself. Revise from a good SQE book and books. Attend and participate in class. Prepare Q&A flashcards. Practice as many SBAQs as possible. I hope I've given you a really good flavour of the type of SBAQ questions you can get, and to really focus on some of the issues that might arise. Subscribe to Community Legal Education on YouTube. Put your notification on. Send me a like if you want. Send me a comment as well. Hope you found the class useful. See you in the next class, and thank you for watching. And I have no idea who that guy is.